Hi everyone. Let's talk about Craig versus Boren. And in your book, I am on page 1502. We already know the court had a rough time trying to figure out what standard applies in gender cases. We started with Reed versus Reed and moved to Frontiero, and the court moved from what seemed to be rational basis review, at least rational basis review-ish, in Reed to strict scrutiny in Frontiero. 1976, so here we go. We have, in the early mid-70s was when the court's struggling with this. Justice Brennan writes the opinion of the court, Craig versus Boren. The dissent, the lead dissent here is written by Justice Rehnquist. His first problem with the case is that the court applies heightened scrutiny in a gender case involving discrimination against males. And Justice Rehnquist doesn't think that males, right, given the history of maleness in the United States, qualifies as a suspect or quasi-suspect or any other kind of suspect classification under the Equal Protection Clause. But you see here in Craig versus Boren, the majority holds that no matter which gender is being discriminated against, the same standard applies. Now, in Craig versus Boren, this case comes to us from the state of Oklahoma, where Oklahoma has a law that 3.2% beer, the normal beer would be, 4, 5, 6% in that range, alcohol. So 3.2% alcohol beer is gonna get the job done, but your normal teenager probably would need a 12-pack instead of a 6-pack, but it'll still get the job done if you drink enough of it, the job. The rule in Oklahoma is that if you're a female who's 18 years old, you can listen to this too, you can purchase 3.2% beer, but if you are a male in Oklahoma, you must wait until you're 21 to purchase 3.2% beer, or what I call near beer, right? We have some near beer cases in constitutional law. So, that's the law. Obviously, you don't have to debate whether that discriminates on the basis of gender. Right on the face of the law, one set of rules for females, another set of rules for males. So, this is the kind of case where if this is an exam question, you go straight to intermediate scrutiny. But speaking of that, it didn't exist yet. Okay, at the time the court decides Craig versus Boren, we didn't have intermediate scrutiny. The court says right off the bat, to withstand constitutional challenge, previous cases establish, did you hear that? Previous cases establish that classifications by gender must serve important governmental objectives and must be substantially related to the achievement of those objectives. That is the standard elaboration of intermediate scrutiny. But when the court there says previous cases established, boy, not so much. Okay, previous cases were jumping around. Justice Rehnquist's second problem with this case, first he says we shouldn't be applying, men don't have equal protection claims under the 14th Amendment. And second of all, he says, if you caught this in his dissent, the court standard of review, this is the top of page 1506, apparently comes out of where? Right? So he's sort of busted them. The majority's trying to sound like, hey, this has been the standard for a while, we've had cases about this. Rehnquist busts them and says no. There is no citation to authority after that sentence, because there is no authority after that sentence for the proposition that this standard of review applies. And he accuses the court of inventing a new standard of review out of thin air. So Rehnquist is thinking, when he writes his dissent, it's bad enough that we have two standards of review that we have to mess around with. It's confusing enough for judges and litigants to deal with that. Now we're inventing a third tier of scrutiny for a third tier of classification, and he is wanting no part of that. Now, before we get into applying intermediate scrutiny to the facts of the case, once again, when we do our live session, I'm going to ask you if you detected any gender stereotypes underlying. Certainly the court did. I mean, you had to catch that out of this, right? The court was not having the underlying gender stereotype about males, right, and particularly young males in this age group, and was saying you cannot punish 98% of males in this age group for what 2% of young males in this age group do. But think about that. Every time you see a gender case, think about, are there gender stereotypes here? If there are, and you can identify them, to repeat what I said in the last video, that's going to be a problem for the government. So let's apply intermediate scrutiny. Under intermediate scrutiny, right, if this was one of those quiz videos, I'd ask you a quiz question here. Which party has the burden of proof? But you've already been asked that, you already know the answer, right? Under intermediate scrutiny, the burden of proof rests with the state. So the state of Oklahoma has the burden of, I should say more accurately, the burden of persuasion. It has to show that it has an important interest at stake. And you can see here how this tracks with strict scrutiny, right? They tend to apply in the same way. Usually the state's going to be okay on the interest side, and it's going to be the means side that gets you. We'll see that again and again. What is Oklahoma's interest? Well, they say our interest is in stopping people from drinking and driving. We don't want people drinking and driving. So the ultimate goal we're trying to achieve here is traffic safety. The court has no problem with believing that that's what the state of Oklahoma is trying to achieve. And so the question is, look at your 4-in-1 matchup. Back to that again. Rule trigger, important interest. Facts, highway safety. Issue is highway safety and important interest. Who's on the highways? The children. You know how this goes. No problem. It's an important interest. It's probably even compelling, but it just has to be important, and it is. So the remaining question for the court is whether the means are substantially related, a good way, a really good way of achieving the interest. And the court here holds, again, there actually are statistically significant differences between male and female in this age range, but still in all, you can only tag 2% of males in this age range with undertaking this conduct. The court says that is not enough to justify this exclusion of men, right, ages 18 to 21, purchasing this near beer. To tell the truth, I always found the majority opinion to be a little bit flimsy on this, not very well explained. However, I would call your attention to Justice Stevens concurring. And on page 1505, if I were a justice on the Supreme Court, I would have really sunk my teeth into this. The Justice Stevens notes, so check this out, this is why I was emphasizing this earlier. The law in Oklahoma bans 18 to 21-year-old males from purchasing, words matter in the law, from purchasing 3.2% beer. As Justice Stevens notes, somewhat bizarrely, the law does not make it illegal for a male 18 to 21 to consume 3.2% beer. Some of you have had teenage kids. All of us have been teenage kids. How long is it going to take teenagers to figure out how to do this? Boyfriend and girlfriend get in the car. Boyfriend and girlfriend drive to 7-Eleven. When they get to 7-Eleven, girlfriend gets out of the car, goes and buys however many 3.2% beers, gets back in the car, and now it is perfectly legal for the 18-year-old male, or at least arguably under this law, to drink the beer. There's no prohibition against him drinking it. So back to my question, does this law match up with the means? You can see where Justice Stevens is coming from here, right? He's saying no. I mean, if you were really trying to achieve traffic safety, and really trying to do it in a way that was effective, right, substantially related, a really good way to achieve it, you would have made it illegal for people in that age range to drink the beer as well as to purchase it. So, Craig versus Boren, the upshot, the bottom line, is Craig versus Boren in 1976 sets the standard that has existed ever since, and it is the bar exam answer. When you see gender discrimination, you look to the government to show, right, it has the burden of persuasion to show that the means are substantially related to an important interest. Here is example one. That is still a tough standard to meet, so it's more like strict scrutiny than it is like rational basis review. That's enough for this video. Hope that helps. That review of those three cases, Reed, Frontiero, and Craig versus Boren, helps put in perspective where we've been and where we are now. Stay safe and stay tuned. Who are you talking to?
Who are you talking to? Look,